Hi, everyone. I'm Britt Burner. First and foremost, I just want to say I hope that everybody and their families remained safe during this terrible weather we had in the past week, and that you lost your power, you're starting to get it back. We're going to be talking today about Article 81 guardianship. So what does that mean? What is Article 81? Article 81 is a section of the mental hygiene law of the state of New York. And this is the section of the law that governs whether or not a person should be deemed incapacitated or if they should be seen as somebody who needs a guardian, and the process by which that should happen and the findings that can come out of it and the results that can happen. And so we're going to talk about the law a little bit and really the implication of it as you're trying to decide if you need to bring an Article 81 guardianship for someone, or hopefully if there's a way to avoid it. We are always trying to avoid the courts when we can. So I want to start by explaining some terminology. We use the term AIP. That stands for the alleged incapacitated person. So if I am a person who believes that my mother needs a guardian, then in that situation, I am the petitioner because I'm bringing a petition for guardianship for my mother, who is the alleged incapacitated person, because I am alleging that she is incapacitated and needs assistance with her affairs. And so that's an important thing to know. If the court then determines after the hearing that she is incapacitated, then we refer to her as an IP, or an incapacitated person. So far we've said the petitioner is the person who brings the proceeding, the AIP is the alleged incapacitated person, and IP is somebody who the court says is in fact incapacitated. And then there's this weird thing we call a PING, P-I-N-G. This is a person in need of a guardian. So I'll give an example of a PING. A PING could be someone who says, you know what, you're right. I need a guardian. I need assistance handling my affairs. I have inabilities that make it where I'm subject to undue influence, or I just can't do it myself anymore. And I know enough to say that, but I don't have anyone to name, or for whatever reason, a guardianship is brought. And that person who can consent to it, so they're not incapacitated because they're consenting, it's determined by the court to be a person in need of a guardian, a PING. And this is another category. And in the end, the powers that are given to the guardian of an IP, an incapacitated person, or of a PING, a person in need of a guardian, are all going to be determined by the court in that proceeding as what is the least restrictive alternative for that person. So the courts always want to do what's the least restrictive form of intervention, and the statute actually tells them that that is what has to be determined. So we're not going to just give all these millions of powers to someone in a situation where it might not be necessary, or where the person who's in need of a guardian or who is determined to be incapacitated maybe has the ability to do some things on their own. So we want to narrowly tailor, is the term we use, those powers around the situation. So let's start with why we'd bring a guardianship proceeding. So I'm going to give you some examples of people we've sat down with who've come in and they've wanted a guardian for a loved one or someone they know. In some circumstances, it's very obvious. You have a family member who had some sort of accident or medical incident that's left them in a coma. They're unable to speak, they're unable to state their wishes, which certainly makes it where they're unable to manage their financial affairs, pay their bills, make medical determinations. They are completely incapacitated in that they're unable to communicate their wishes. The next question is, did they appoint anybody to act on their behalf? So did they sign a power of attorney? Did they sign a healthcare proxy? Because if they did sign those documents, then there might very well be somebody to act on their behalf. So let's say they did sign a power of attorney. Then the next step would be, are the powers listed in the power of attorney, the powers that the agent has, are those powers sufficient to take care of the needs of this person? And if they are not sufficient to take care of the needs of the person, or if the power of attorney and healthcare proxy were never signed in the first place, then we might be in a position where it makes sense to bring an Article 81 guardianship proceeding, asking the court to appoint a guardian over this individual to assist them in their affairs. Now, that's a relatively simple situation in terms of, is someone incapacitated? Because they're unable to communicate or do anything on their own completely. So a lot of times it's a lot more gray area. Let's take somebody who perhaps has some dementia. They are unable to balance the checkbook anymore. It's very difficult for them to go through the mail and process what bills need to be paid. Bills are going into arrears. There's a lot of money owed. Collectors are calling. Maybe they're getting phone calls that are scams on the phone, and they're completely unable to manage these different parts of their life because of the cognitive inabilities that they have. Well, in that case, a guardianship proceeding could be brought for that person. I would go through the same questions as I went through with the totally incapacitated person. Have they signed a power of attorney? Have they signed a healthcare proxy? If not, then there's nobody to act. If they haven't, do they still have the capacity to sign those documents? Because just because somebody has dementia or some other cognitive inability, it doesn't just mean they can't sign documents. It's got to be, do they have the ability to understand what they're signing and to give those powers away? They can sign the documents, great. If they can't, we go to guardianship. If they do have the documents, again, do those documents have the powers in them that are necessary to handle the affairs of that person, or are additional powers needed? And if they don't have the ability to give those additional powers, we need to ask the court to give those powers. So let's say we're in a position where we say, you know what, this person does need, my understanding is that my loved one needs me to bring a guardianship because they are unable to handle their own affairs. Well, in that case, the next question I always ask is, what are you trying to accomplish? So this goes to the question of when I said, does the power of attorney or the healthcare proxy have the powers in it, or are there additional that you need? So big question, especially when we're talking about some cognitive inabilities, or if we're talking about somebody with mental illness, what are we trying to accomplish by bringing the guardianship? Now, if somebody says to me, I'm trying to accomplish my mentally ill sibling being forced to take their medication over objection, the answer would be an Article 81 guardian can't force somebody to take medication. That's a different proceeding where somebody can be given treatment over objection. So that's not going to be in this category. Or someone says to me, I want to be able to put them in a nursing home. They can't stay at home anymore. It's unsafe. I need to put them in a nursing home. Well, the court's not just going to give the power to place somebody in a nursing home. There's a big preference for keeping somebody in their home if they could be maintained in their home. Beyond that, even if you're appointed guardian, you'll always have to come back to the court in order for the court to determine if that person can be placed in a different residential setting than the one they're currently in. There's also the practical concerns. So the court may say after the proceeding, yes, you have the power as guardian to place this person in a facility, but that's not going to do anything for the person who, when you get to their house, they won't go. Or the person who, once they get to the facility, can they be locked in the facility? So there tend to be some nuances there that really create issues, especially when you have an able-bodied person who maybe has some sort of mental illness or cognitive inability. So a guardianship, the important thing to notice is it's not going to solve every problem. Some of the problems will just remain because that person has a mental illness or has a cognitive inability to understand what's going on. So when you bring a guardianship petition, you write a petition. Usually somebody would hire an attorney, although you don't have to say all the reasons why somebody's unable to handle their own affairs. We like to give anecdotal things of examples of bills unpaid, of scam scams being followed through with and money being stolen, whatever the things may be in that situation, we lay them out in the petition for the court. If the court gets that petition and feels that there's enough in there to investigate further, the court will sign an order appointing a court evaluator, and in certain situations, appointing a lawyer to represent the individual, and setting a court date. Now, things are a little bit different in COVID because the courts are operating via Skype, but the statute says that the court must bring the hearing within 28 days. So it's a fairly quick process. And in that 28 days, the court evaluator's job is to interview the AIP, the alleged incapacitated person, interview the petitioner, and interview anyone else that may be identified as somebody who has an interest in the proceeding, an interest in this person being deemed incapacitated or not, and anyone who might have information. For example, if there is a home health aide, and the home health aide is someone who's with the individual all day long, they may have very important information as to what this person can and can't do on their own, and that may assist the court evaluator. Because the court evaluator's job is to do this investigation, write a report, and then testify at the hearing and recommend to the judge who's presiding over the case if somebody needs a guardian, if they are in need of a guardian, who should the guardian be, and what should be those narrowly tailored powers that form the least restrictive form of intervention. And so the court evaluator really needs to gather as much information as possible in order to really advise the judge. We often call the court evaluator the eyes and ears of the court. The judge can't go out in that 28 days and gather all that information with all the cases on their docket. So this is someone that they can send out to do those investigations for them. Some of the people that the court evaluator interviews may end up testifying at the hearing if one of the parties calls them, but that is the court evaluator is a very important part of the process. There's a list called the Part 36 list. This is a list of mostly attorneys, although there are some non-attorneys on this list, who are people who've taken the course and qualified to be court evaluator and have put themselves forward to the court as someone who's willing to serve as court evaluator. I, for example, have served as court evaluator on many cases, and I will go out and I will do those investigations and make my recommendations to the court. In that petition, you're going to want to say there's a power of attorney, but it doesn't have enough powers, or there's a power of attorney, but this person's not willing to act anymore, or there's a power of attorney, but the person's not doing a good job and I think they might be stealing. You know, that's an extreme case, but it does happen. So these are the different scenarios and the information you need to put into that petition to make sure that you're telling the judge all the important things they need to know to determine if this person should have a guardian appointed for them. The hearing then takes place. When you send out that order setting the date for the hearing, you have to give notice to the spouse of the person, if they have one, any adult children. If their parents are living, their parents need to get notice. Any adult siblings of that person, or anyone with whom that person resides. These are all people that are determined to be interested parties who get notice of the proceeding. That doesn't necessarily mean that they are full participants in the proceeding, but that's a legal issue that we won't deal with so much today. But those people all need to know that this proceeding's happening. So if they want to come forth and appear in the proceeding, they have the ability to do so. So once that hearing is held, the court has to determine its findings, we say. So what are the findings that the court has to come up with? So again, they need, in all cases, a functional limitation, at least one, that impairs the person's ability to provide for their personal needs and property management. They need to show that there's a need for a guardian. You can't just say, my mom's incapacitated, she should have a guardian, but nothing's happening. You need to show that a guardian is required in order for this person to continue living on and have their assets be taken care of and used for their benefit. Even if you're in a situation where the person consents to having a guardian, they say, yes, you know what, you're right, I do have some failings, I will agree to have a guardian. You still need to show the need. You still have to show that it's a necessary thing for this person to be under guardianship. You need to show, if you're trying to show somebody is incapacitated, so not somebody who is agreeing or consenting to a guardianship, you need to show that this person has a lack of understanding of lack of understanding and appreciation of the nature and consequence of their inability. So what does that mean? That means that you have to show that, for example, my mom didn't pay her electric bill, and she doesn't understand that by not paying her electric bill, they're going to turn off her electric. And perhaps she uses that for cooking, she uses it for lights, for air conditioning. That could be harmful to her health. She may not understand the consequences of not paying that bill. And so you need to show that somebody doesn't understand the consequences. Now, why is that important? Because you can't just have a guardian for someone because you disagree with their choices. We'll take alcoholism, for example. We have seen many guardianships where someone is an alcoholic, they drink too much, they may injure themselves when they're drunk, they may fall down, they may forget to do things, but they fully understand that this is the case. And they understand that they are falling down on the job in terms of paying their bills or handling their affairs. This doesn't necessarily mean that the court is going to appoint a guardian, because somebody who has this kind of an illness, they have the ability to make those choices. And the person, the daughter, the son, the spouse, whoever it is, may find that those are bad life choices. But if somebody has the cognitive ability to make bad life choices, then they might not need a guardian. So it's very important to realize the nuance of when somebody needs a guardian. And this lack of understanding the consequences is a big part of that. If you say, you know what, I'm going to be unable to use my legs and be in a 5th floor walk up, and I understand that if there's a fire, I could be in big trouble, but I'm willing to assume that risk, and you have the mental capability to understand that, well, then that doesn't mean you need a guardian. And I had that case. I had that case in Manhattan, and a nursing facility didn't want to let a woman out of the facility because they said she wouldn't be safe at home. But she was 103 years old. She'd lived in her apartment for 60 years. She wanted to go back to it. And she understood that if there was a fire, she might not make it out on time. But that was a risk she was willing to take, and she understood that risk. And the court found that she could go home and she didn't need a guardian because she was able to understand that risk and make that choice for herself. So we're not looking to take away people's free choice here. We're just looking to protect those who can't protect themselves because they don't have the ability, the cognitive ability to do so. The other thing you have to show is that somebody is likely to suffer harm because of their inability and their lack of understanding of the consequences. And you show that the guardian would be able to prevent that harm. So those are the important findings that have to happen, that somebody has the functional limitations that we're talking about and needs a guardian, that they don't understand and appreciate the nature and the consequences of their inability to understand, that they're likely to suffer harm, and that a guardian could prevent that harm. Again, then once we determine this person needs a guardian, that they're incapacitated or that they consent, and then the court determines who the guardian should be. So this is usually either the petitioner, so I'm bringing a guardianship asking to be appointed as the guardian for someone, or someone off this Part 36 list, that same list where we found the court evaluator. There are people who can elect to actually be the guardian on that list, and the court can go through that list and determine, again, most of the time those are attorneys, although not always, and they can determine that this is going to be the person that's going to be named. We call that an independent guardian. That's someone who's independent of the family, independent of the individual, who is just being appointed by the court because there's no other appropriate person, either because the person has no family or friends who are willing to act, or because the family members are fighting so much that an independent person needs to come in order to simplify the situation and make sure the person's taken care of without everybody else's agenda coming into play. The other option is for the family or the petitioner or other parties to nominate a guardian. So this could be an individual, this could be a private individual, it could be a lawyer. It's a nomination, so the family might say, we can't act and we can't agree, but we all agree that this independent person would be good, the accountant, the lawyer, some other person, and we want that person to act as the guardian of our loved one. And again, it's all, even with a nomination, it's still going to be up to the judge to appoint that person. Once somebody is appointed, then we determine what powers that guardian will have. So I talked about this a little bit when we started. When you have someone who's appointed as guardian, what does that mean? It's going to mean something very different in every case. You may have that case where somebody's in a coma and you need a guardian to have every power under the sun because that person is completely unable to act on their own behalf. Or you may have a guardian that's just going to take control of a small bit of money and make sure that the bills are paid, and that's all they're going to do. Or they may need the ability to settle a lawsuit. Perhaps the individual is involved in a lawsuit. Maybe they're incapacitated because of a personal injury action and nobody can actually sign off on the paperwork to hire the lawyer to file the complaint for the personal injury suit, to settle the case and receive the funds, to set up a trust to hold the funds from the personal injury suit. So every person's situation is going to dictate what those powers will need to be. So just like when people say to me, well, I'm power of attorney, so I can do that. I say, well, not so fast. Let's see that power of attorney. Let's see that document and see what powers you've been given in that document. It's going to be the same for a guardianship. If somebody comes in to see me and says, I'm the guardian for my sister, can I do X, Y, or Z? I'm going to say, I can't answer that question until you show me the order appointing you so I can read what powers that judge gave to you. And if you don't have those powers, well, we may need to petition the court again to expand the powers, to add powers, because either they were mistakenly not given in the first place, or more likely, circumstances have changed and additional powers may be necessary. Another example of something that's going to happen after the guardian's appointed, other than looking for expansion of powers, is, for example, in New York State, you have to petition the court to allow you to sell real property. So what does that mean? Well, let's say somebody is incapacitated and they own their home in Queens. And before the guardianship even started, they moved into a nursing facility and they live there full time, and the intention is that they will stay there full time and not go back home. But now the home has to be sold, either to effectuate a Medicaid plan or to pay the facility or transfer the assets, whatever has to be done. You have to go to court as guardian and ask the court to bless that sale. And you need to show that it was put up for fair market value and what the comps in the area are. And each judge in each county is going to have their own requirements of how they hold this type of hearing, but you need to ask the court for that further relief. You're not just going to have that in the initial order, the ability to sell real property without coming back to the court. A guardian also has to take a training course. The court's going to make sure that the individual does not have any criminal record, that they were never on a sex offender registry or a domestic violence registry, and they might need to be bonded. So what does that mean? Well, if somebody has $300,000 in assets and the guardian's going to take control of that $300,000, then that person whose guardian is going to have to apply for a guardianship bond with a surety. So basically security on that money in case something goes wrong. And in order for somebody to be bondable, they need to be able to put up collateral. So if the guardian is an attorney with malpractice insurance and other insurances, or is an individual who owns their home, that could be the collateral, or has other assets, whatever it may be, this company, this bonding agent needs to determine that that guardian can get a bond, and then there's annual fees paid on that bond. The other thing that's really important for a guardian to understand is that you need to account to the court. Now, when you're first commissioned as guardian, that's the word we use when you get your final document with the raised seal saying you are guardian, you have 90 days to submit an initial report. We call it the 90-day report. This report says what you've done in those first 90 days, because there should be a lot of activity right at the beginning, right? You're taking control of the money, you're paying back bills. You might be setting stuff up on auto pay, getting that person to the doctor because maybe they haven't been to the doctor in a long time. And if you have powers that are over healthcare decisions and the healthcare of that person, you're going to want to get them checkups. You're going to report all this to the court in that 90-day report. Then every May, guardians have to account to the court. I once heard a judge say that if you buy a stick of gum for 5 cents, I want to see on the accounting that you bought a stick of gum for 5 cents. This is where the guardian oversight comes from. The court has court examiners who are persons who are appointed to review these accountings every year. And if they see no issues, they tell the court to see no issues, the order is signed by the judge and the accounting is approved. If they see issues, usually they'll go back to the guardian and say, what happened here? And maybe they have to provide a little more information or explain something that had to happen. You know, there was some big expense that was unexpected and they have to document why that was done. And then if they are not satisfied, then the court examiner has to let the court know, I think there's a problem here. And the court's got to get that case back on the docket to figure out, did that guardian take money they shouldn't have taken? Are they a bad guardian? You know, maybe the person is further in debt and, you know, has a stoppage of benefits or whatever it is that needs to be handled by the court to make sure we either get that guardian back on track or they're removed and a new guardian is brought in. So that's what's done after the guardianship to make sure that that person is still living up to their job as guardian. I think that's it for the examples. I want to answer, I know we have at least one question I want to answer, and then that may bring up some additional things from other people. So Liz, we can read out this first question.
You got it. Our mom, 79, is showing distinct signs of dementia. She lives in California. Are the laws within each state very different regarding this?
That's a great question. So yes, the laws are very different. In other states, they actually even use different words. I use guardian, and because in New York, we have guardian of the person, healthcare decisions and the like, guardian of property, those are financial decisions. Other states, they use the term conservator, and every state does have its own system. New York State is, that is the Mental Hygiene Article 81. That is a New York State statute. Now, there are other states that have what's called the Uniform Guardianship Act. It has a much longer name to it, but there's a Uniform Guardianship Act. New York actually adopted it a few years ago. And what that's supposed to do is deal with people who are going from state to state. So let's say mom lives in California, or I think California has signed on, I'd have to check, but most states have. Florida has not, I know that. Let's say mom lives in New York, where I know there's a Uniform Guardianship Act, and she is taken by one of her siblings or one of her children to Pennsylvania. She's brought out of state, and either against her will or she doesn't know the difference. And the child who was with her in New York wants to bring a guardianship to get her back to her home state. There is this Uniform Act that will allow someone to bring a guardianship in New York because that's mom's home state. But yes, to answer your question more simply, the laws for guardianship will differ from state to state.
Thank you. Next question. Is there a set amount of fees that a guardian appointed by the court is entitled to? Is it yearly?
So that's going to, again, be on a case-by-case basis. And that is something that when the judge does the initial guardianship proceeding, they will determine what the appropriate fees are. I'll give some examples. I've had cases where it's a family member who waives the fee and says, I don't want a fee. I'm very happy to do this. I would have been power of attorney. She never signed the papers, but I'll serve as guardian and I don't want any fee. There are situations where the fees that are similar to those that an executor would receive, which is a sliding scale based on the percentage of the assets handled, et cetera. It's a complicated calculation. Those are the fees and they are determined annually, but only after those accountings are approved. There are other cases with special situations where the guardian can be awarded a monthly stipend or commission. And that's mostly in cases I see with, a lot of times it's with younger incapacitated persons where maybe they had business interests that had to be kept up or something else that makes that guardian's job more than just checking in, paying the bills, and making sure they go to doctor's appointments. It really becomes a full-time job, and then sometimes an additional stipend will be awarded. A stipend's also awarded sometimes in a guardianship where there's a Medicaid case, because depending on the county and the circumstances, that can often be paid before Medicaid is given any funds. So a stipend is sometimes used in those cases as well. Someone just wrote the $1,200 stimulus check. I'm assuming that that's a Medicaid related question because of what I just said, so I'll answer it. What the $1,200, can guardians spend that money? So yeah, the stimulus check would be deposited into the guardianship bank account, just presumably like the Social Security would be, and the guardians can spend that money as it is the money of the individual. So the same way, but they will have to account to the court for the fact that that money was deposited and then how it was spent. Okay, I think we are set. Well, thank you again to everyone for joining us, and we'll see you again soon. Have a good day.